as they come. Actually, most of the residents, abana bo banywedde breakfast. It is the media and bali emabega baze to so but yes, the reasons are
Can I just check in how many people have not had breakfast?
first that. All protocol observed. Good morning, everyone. You're very welcome to day 2 or the final rounds of the annual constitutional law Moot convened by SEHAD. We are happy to have you today, and we hope that all of us are ready, and the finalists are also ready to proceed for today. And without further ado, I'm going to call upon the Executive Director of the Center for Health, Human Rights and Development, Ms. Fatia Chiange, to come and officially welcome us, but also officially open day 2 of the Moot as we prepare to start. Ms. Fatia, you're very welcome.
Thank you so much, colleague Esther. Honorable Lady Justice Susan Okalanyi, Honorable Lady Justice Naluze Aisha Batala, Honorable Lady Justice Rosette Comfort Kanya, Her Worship Edimu Helen, His Worship Okom Jude Amwone, all key stakeholders that are here. We have civil society, our partners, the lecturers, the patrons, the Moot coordinators, and students from the 13 participating universities, the media, fraternity, and our online participants. Allow me to take this opportunity on behalf of the Center for Health, Human Rights and Development, SEHAD, to warmly welcome you to this 11th Annual National Inter-University Constitutional Law Moot Court Competition. We take pride in this annual Moot event, which is one of our innovations that has been nurtured and sustained since 2014. It is one of those annual events we look forward to and host with a lot of enthusiasm. Yesterday, the whole day, we had the preliminaries, we had the quarter and semi-quarter finals, and today is the final day, the climax of the Moot competition, where we are having the finalists. And I want to congratulate them for being the finalists from yesterday's event. The Moot is one of the approaches used by the Center for Health, Human Rights and Development to interest and nurture law students into the art of advocacy, introduce them to court decorum, and practical aspects of litigating the right to health. Recalling that the right to health encompasses healthcare services, but also most importantly, the social determinants of health. The event inspires and ushers the young generation of lawyers to consider a career in human rights law, which aims to protect the rights of the most vulnerable members of our society. It provides an opportunity for students to interact with you, our honorable judges, and for you, our honorable judges, to interface with the practical aspects in the area of sexual and reproductive health and rights and gender justice in our country, especially for those that are most vulnerable, those that are powerless, and those that do not necessarily have a voice, even when they should have a voice. The Moot mirrors the importance of a combined approach of litigation and advocacy in the realization of social justice in health. As we are all aware, we have so many injustices in our healthcare system that disadvantage the most vulnerable. And this Moot aims to prepare the young lawyers to be able to address those injustices in the healthcare system, because at the end of the day, we should have a healthcare system that integrates social justice and also human rights to benefit the most vulnerable members of our society. SEHAD's litigation journey started way back in 2011 with the now famous Constitutional Petition 16 of 2011. In the years that followed up to 2014, when we innovated the Moots, SEHAD had litigated several other cases, including one on child theft in Mulago Hospital, which led to many changes in Mulago Hospital, including surveillance with the cameras and ensuring that the babies are actually labeled. So many changes to reduce that vice where babies would disappear from Mulago Hospital. We litigated on maternal deaths in Nakaseke. We also litigated one challenging the Penal Code Act for referring to persons with mental disability as idiots and criminal lunatics, which is not the case because they are human beings like anybody else. Such litigations motivated us to think about exposing students in schools to such scenarios where they interface with actual court settings to prepare them to argue cases of the right to health before courts of law in our country, but also be examples in the rest of the region, East Africa, also Africa and globally. And we know that law moots now have even taken a regional dimension. At that time, various universities had started taking an important academic courses, such as a course on health law and policy as alternative course units. A student was at liberty to choose whether to take on such a course or not. We found that some of the students who had taken such a course at university were undertaking impactful work and provided leadership for litigating the earlier cited cases that were impacting positively on our society. The Moot enables us to introduce and inculcate a culture of advancing the right to health to students who may not have had an opportunity to take on the course at the university, to build their capacities into actual aspects of litigating health and human rights within Uganda's courts of law. We work with judges and magistrates from various courts within the country to preside over the moots. We are grateful that the students that have gone through such rigorous processes have never remained the same. In fact, we see them going into human rights law to protect the rights of the most vulnerable. The judges and magistrates continue to nurture the students with lived experiences of litigating the right to health, drawing examples from what they see in courts of law. This year's 11th annual Inter-University Constitutional Law Moot Court competition has been designed to expose students to litigating legal aspects relating to reproductive health and gender justice within Uganda's courts of law through the use of hypothetical moot problem. The competitions draw experiences and expose students to litigating cases before the High Court, the Court of Appeal, and the Supreme Court of Uganda. This time we had a total of 14 universities that expressed interest, and 13 of these were selected to participate in the competition. These include Makerere University, Uganda Christian University Mukono, Uganda Pentecostal University Kampala Campus, Uganda Pentecostal University Fort Portal Campus, Cavendish University, Islamic University in Uganda, Mbale Campus, Islamic University in Uganda, Kaboja Campus, Islamic University in Uganda, Kampala Campus, Nkumba University, Kampala International University, King Caesar University, International University of East Africa, and Gulu University. SEHAD appreciates these universities continuously engaging in the moot. We also extend our sincere appreciation to the leadership of the universities for providing support to the students through the moot coordinators to engage in this important process. SEHAD offers opportunities for internship to those who make it to the top in these competitions, and we look forward to receiving those that will make it to the top for internship, to nurture you and to give you an opportunity to see human rights law being applied in practice. I wish the finalists. Before that, I would like to appreciate our lordships for accepting to be with us today. It's a very busy time of the year and we cannot take that for granted. We thank you for being here to inspire the young lawyers for the benefit of our communities. I wish the finalists good luck as we embark on the final stage of the moot process for God and my country. I thank you.
The Supreme Court of Bukoma is in session. Supreme Court Civil Appeal number 1 of 2024. The parties appearing before the court today are the Attorney General of Bukomo and Salbona Hospital, appearing as the appellants, versus the Amani Health Lawyers Initiative and Dr. Benny appearing as the respondents.
Thank you so much. It's not customary for the court to introduce itself. That is not the procedure, but for purposes of this moot, since the court was constituted this morning, I'll take this moment to introduce this Court of Appeal. I have before me, before you, His Worship Okumu Jude, the Registrar, Assistant Registrar of the Commercial Division of the High Court. And then I have Her Worship Helen Edimu, Assistant Registrar of the High Court Circuit of Tororo. Immediately on my left, Her Lordship Rosette Comfort Kania, a judge of the Criminal Division of the High Court. On the far left is Her Lordship Aisha Naluze Batala, a judge of the Land Division of the High Court. Myself chairing this panel, my name is Susan Okalai. I'm the Deputy Head of the International Crimes Division of the High Court. We are expecting the appellants to argue their case in 20 minutes. And the reply from the respondents is also 20 minutes. So you know how to allocate time amongst the two counsel on both sides. For the rejoinder, you will have 5 minutes. So we are going to be very strict about time, because in real life, that is what happens. I do ask you to relax. It's a competition, isn't it? But relax, enjoy yourselves as you make this presentation. This is the only time it's happening in this place, as far as this moot is concerned. And I'm very certain that you'll be quoting this for the rest of your life. It might even be part of your CV. And I'm telling you the truth. I was the students' vice president of the Students' Guild at Makerere. It is still in my CV. Can you imagine? And it counts many things. Whoever sees it says, yes, this is a leader. So enjoy yourselves as you do your best. Can we then hear the case for the appellants?
Much obliged, Your Lordships. May it please this Honorable Court, my name is Masolo Adrian, the Attorney General of the State of Bokomo, appearing with my co-counsel, Gloria Mainuka. The respondents in this matter are represented by Nanyunja Shakira and Tamale Ahmad. Your Lordships, we have been allocated 20 minutes of this Honorable Court's time. I will use 12 minutes to address this Honorable Court on grounds 1 and 2 of the appeal, and my co-counsel will use 8 minutes to address this Honorable Court on ground 3 of the appeal while making prayers of the appellant, and we reserve 5 minutes for rejoinder. Your Lordships, with your permission, I beg to proceed. Much obliged, Your Lordships. Your Lordships, this Honorable Court today is faced with a fundamental question. How do we balance the right to health of a pregnant mother? And we, the appellants, do acknowledge that mothers, women, are a fundamental pillar of the society of Bokomo. And how do we balance her right to health with the right to life of the unborn child? A possible life, a possible member of the state of Bokomo, a possible lawyer, a possible engineer, doctor, or even justice of the Supreme Court and other subordinate courts, who unfortunately, due to the laws of nature, cannot speak for itself. Your Lordships, it is on this basis that we are before this honorable court, pursuant to Rule 31 of the Judicature Supreme Court rules, with a prayer that this honorable court sets aside the judgment of the Court of Appeal and confirms the ruling of the trial court, Your Lordships. Your Lordships, with that brief preamble, I beg to proceed to submit on the first ground of appeal. Much obliged, Your Lordships. The first ground of appeal is that whether the Court of Appeal justices erred in law in holding that Dr. Abeni's dismissal was solely premised on her pregnancy and hence should be reinstated as a surgeon with full benefits. In submitting under this ground of appeal, the appellants shall make two head arguments. One, that Dr. Abeni's dismissal was lawful, and that two, the Court of Appeal erred in ordering that Sawubona Hospital reinstates Dr. Abeni in her position as a surgeon with full benefits. Your Lordships, proceeding to my first head argument, the appellants submit that the Court of Appeal wrongly applied the provisions of the Employment Act in holding that Dr. Abeni was wrongly dismissed from Sawubona Hospital. Your Lordships, Section 68, subsection 3 of the Employment Act states that an employer shall be justified in dismissing an employee in the event of fundamental breaches of their contractual obligations. Your Lordships, if I may refer this honorable court to page 6, paragraph 5 of the record of appeal. Your Lordships, Dr. Abeni indeed violated her contractual obligations. In what ways? Your Lordships, Dr. Abeni led to the death of a patient as a result of her failure to sterilize instruments that were to be used in a surgery. Your Lordships, this patient is 6 feet under. Additionally, Dr. Abeni had become non-responsive to her assignments. Dr. Abeni had started coming late to work, Your Lordships. The appellants therefore submit that Sawubona Hospital was indeed justified in dismissing Dr. Abeni. Your Lordships, additionally, Dr. Abeni signed an employment contract, which employment contract stipulated that there is a no marriage, no pregnancy policy. Your Lordships, Dr. Abeni agreed to be bound by this policy. The appellants therefore submit that the Court of Appeal erred in holding that this policy was unfair as a reason for her dismissal. Your Lordships, in the case of Dimanche Sharon and others versus Makerere University, 2006, Uganda, the Supreme Court, in particular Kanyehamba JC as he was then, stated that by its very nature, waiver of any right must be voluntary, freely expressed, and with a clear understanding of the true consequences and effects of so doing. It is to be effects. Your Lordships, when Dr. Abeni signed the employment contract, she voluntarily waived her right to access an abortion, and she confirmed that she would be bound by the no marriage, no pregnancy policy. The appellants therefore submit that because she accepted to be bound by this provision, the Court of Appeal erred in law when it held that the use of this provision to dismiss her was unfair. Your Lordships, if I may persuade this court with the case of Fernandez Martinez versus Spain, application number 5630 of 2007, the Grand Chamber of the European Court of Human Rights stated that the duty of loyalty can only be invoked by religious authorities on condition that the collaborator has knowingly and voluntarily agreed to it. Your Lordships, in the record of appeal, it is clear that Sawubona Hospital is a church-founded hospital whose policies are banked on religious doctrine. Your Lordships, the court of the appellants submit that she was bound by these policies, Your Lordships.
Counsel, what is the ratio decidendi of that other case that you would like to persuade the court with?
Of Fernandez Martinez versus
the
Spain?
Spanish case, yes.
Much obliged, Your Lordship. In response to your question, the ratio decidendi is that institutions have religious autonomy to institute policies that are grounded in their religious doctrine. And if one agrees to bound by these religious doctrines, Your Lordship, if one agrees to be bound by these religious doctrines, they cannot then state that they were, after they have been used against them, they cannot state that they were unfair, Your Lordship.
Before you go ahead, clarification on the type of the contract Dr. Ben signed. Do you find that contract lawful? And what is your justification?
Much obliged, Your Lordship. I do find that contract lawful. It is an employment contract, Your Lordship. I do find that contract lawful because, as I have stated in the persuasive case of Fernandez Martinez versus Spain, an employer is employers have religious autonomy and can therefore include policies in employment contracts that are based on religious doctrine. So our basis for submitting that this policy was lawful is that the employer has religious autonomy, Your Lordship. Your Lordship, moving on to my second head argument under the first ground of appeal.
In other words, you are saying that it's not an illegal contract.
Yes, Your Lordship.
Okay.
Moving on to my second head argument, that the Court of Appeal erred in law in ordering that Dr. Abeni should be reinstated. Your Lordship, the Court of Appeal wrongly applied Section 70, subsection 6 of the Employment Act, Cap 226, in ordering that Sawubona Hospital should reinstate Dr. Abeni. Your Lordship, Section 70, subsection 6 of the Employment Act, subsection B, states that an employer cannot be ordered to reinstate an employee in the event that reinstatement would be intolerable. Your Lordships, page 6, paragraph 5 of the record of appeal shows that Dr. Abeni had engaged in various arguments with her supervisors. Your Lordships, the appellants submit that ordering the employer to reinstate Dr. Abeni would be intolerable. Additionally, subsection C of the same provision states that reinstatement cannot be ordered when a dismissal has been termed unfair. The appellants submit that in the event that this honorable court decides to agree with the Court of Appeal that indeed the dismissal was unfair, we submit that the Court of Appeal still erred in ordering that Dr. Abeni should be reinstated. Your Lordships, having submitted on the first ground of appeal, I will now proceed to the second ground of appeal.
Did you try to look at the provision of the Constitution in the submission vis-a-vis the fact and find out whether what the employer did was lawful?
Yes, Your Lordship, I did.
Which part of the Constitution or article did you file your submission to?
Article 29 of the Constitution of Bokomo guarantees the right to freely practice religion. Your Lordship, we submit that the employer, in practicing this right to freely practice religion, can include policies in the employment contract that are stemmed from the religious doctrine, Your Lordship. Much obliged, Your Lordship. I will now proceed to the second ground of appeal, that is, that the Court of Appeal erred in law when it held that the failure of Sawubona Hospital to provide Dr. Aben with quality sexual and reproductive health services violated her right to health and reproductive health services. Your Lordship, the appellants do recognize that the right to health is a fundamental right in the state of Bokomo. It is on this basis that the state of Bokomo has domestically passed a number of provisions in the Constitution of Bokomo, including Article 8A, Article 45, read together with Objectives 19 and 20 of the National Objectives and Directive Principles of State Policy that guarantee the right to health. Your Lordships, additionally, the state of Bokomo has ratified international treaties and conventions, including the International Convention on Economic, Social and Cultural Rights and the Convention on Elimination of Discrimination Against Women, that recognize the right to health internationally. Whereas the respondents may argue that it is not enough just to pass laws, we should also carry out measures. Your Lordships, in the record of appeal, it is clear that the state of Bokomo has also carried out these measures. Your Lordships, Sawubona Hospital, which was a non-government private hospital, was experiencing financial troubles in 2020 as a result of the COVID pandemic. The state of Bokomo bailed out Sawubona Hospital with a 90% share, Your Lordships. Much obliged.
National objectives in the Constitution. Are they law applicable?
Yes, Your Lordship, they are law applicable. Objective 1 of these objectives states that these objectives shall be used and shall guide the government in drafting state policy, Your Lordship.
Yes, but do they guide the courts in making decisions? That's an authority that I was looking for.
Yes, Your Lordship.
Do you have that authority?
No, Your Lordship.
Okay. And then in what respect were you citing the international convention?
The international conventions,
What are you supporting
much
with
obliged.
those conventions? What actions of the state in this case are you supporting?
Much obliged, Your Lordship. In those conventions, I am supporting the actions of the state in recognizing the right to health, Your Lordship. Pursuant to Article 45 of the Constitution of Bokomo, it recognizes that there are other rights that may not be included in the Constitution of Bokomo, which include the rights included in the international conventions, Your Lordship.
So how do you apply it to your facts?
Much obliged, Your Lordship. Your Lordship, these international conventions require that states should take measures to protect the rights of citizens, especially the rights to health. Your Lordships, in the record of appeal, we see that the state has taken steps to ensure that it protects the right to health. As I stated, the state bailed out Sawubona Hospital with a 90% share when it was facing financial troubles. This is a testament that indeed the state has taken measures to recognize this right to health.
Okay.
Much
Counsel, you don't have a lot of time.
Much obliged, Your Lordship.
Maybe, and I don't know how you're dividing the time.
Much obliged, Your Lordship. I will now yield the floor to my co-counsel to submit on the third ground of appeal.
Thank you.
May it please this honorable court, as earlier introduced by my co-counsel, my name is Gloria Mainuka, and I'll be submitting on the third ground of appeal that states that the court erred in law in holding that the failure of Bokomo State to put in place laws and policies that guarantee safe and legal termination of pregnancy has resulted to the high maternal mortality ratio in the state of Bokomo. With your lordship's permission, I beg to proceed. Moving to the appellant's head arguments, the appellant submits that the state of Bokomo has taken steps to ensure the full realization of the right to health, and this has been met by its citizens. And secondly, that the restriction on non-therapeutic abortion is essential to the maintenance and respect of the public morality in Bokomo. And thirdly, that the high maternal mortality rate cannot solely be attributed to non-therapeutic termination of pregnancy. Your Lordships, the state of Bokomo has taken steps to ensure that its citizens have realized the right to health, and this is pursuant to the policies that they have set to therapeutic abortion. These policies are set out in the national guidelines that provide that there's therapeutic abortion on the grounds therapeutic abortion can be accepted. Furthermore, the restriction...
Those guidelines are for which year? Which guidelines? We are totally agreeing about the guidelines that you're talking about now.
Much obliged,
Yes.
my lord. These are the guidelines set out in August 2017.
Okay. And which guideline are you referring to?
The National Guideline on Policies Set for Reproductive Health,
Guideline
number 13.
Okay. You said it's August which year?
2017.
Proceed, Council.
On the second limb of argument for the appellant is that the restriction on non-therapeutic abortion is essential to the maintenance and respect of the public morality of the citizens of Bokomo. This is pursuant to Article 22 of the Constitution of Bokomo, which states that the right to life has to be respected, and as such, in respecting the culture and the public morality of the state of Bokomo, we see that we have to respect the right to life, because the culture in Bokomo is that the right to life has to be respected, and that legalizing non-therapeutic abortion will cause non-humility and non-humbleness in the state of Bokomo. Moving to my third limb of argument, the high...
Just a moment.
Yes.
Those guidelines provide for instances where somebody probably has been raped or a child has been impregnated by a father, and if so, how would you determine a patient arriving before you and you're making a determination that this pregnancy is immoral and therefore you would not help to give patient health?
Much obliged, Your Lordship. In regard to the guidelines, the national policy guidelines, the instances or circumstances when abortion can be accepted are instances where the life of the mother is at risk, and the risk would be in instances of preeclampsia and hemorrhaging, and in instances of rape, incest, and defilement of the girl child or the woman.
For a woman coming to you hemorrhaging has an incomplete abortion, that does not meet the test of threat to life, or you consider that voluntary?
Much obliged, Your Lordship. We consider that as a test to respect the right to life. Okay. Moving to the third limb of argument, it's that the high maternal mortality rate cannot solely be attributed to unsafe or non-therapeutic methods of abortion. As earlier stated, the state of Bokomo has set policies and guidelines on when therapeutic abortion is accepted in the state of Bokomo. And as such, the high maternal mortality rate cannot be allocated just to non-therapeutic abortion, because non-therapeutic abortion rates are counted as a 7% towards the maternal mortality rate in the state of Bokomo. The maternal mortality rate in the state of Bokomo, as seen in the World Health Organization analytical fact sheet of 2023, it allocates at 15% to hemorrhaging, 17% to obstetric care, and at 7.5% to abortion-related issues. And thus, Your Lordships,
You're saying 7%
towards non-therapeutic abortion.
15% to hemorrhaging.
Yes, Your
The
Lordship.
other percentages?
The other percentages are to other instances that have led to the high maternal mortality rate. In moving on,
So what has the state done to see that those percentages in the World Health Organization percentages are incorporated in the health sector of the Congo state?
much obliged, Your Lordship. Looking at the record of appeal, it's the appellant's position that the state of Bokomo has placed a 10% budget allocation to the sector of health. And in that 10% allocation, it's the appellant's position that it's going to improve the health infrastructure in the state of Bokomo. And on that health infrastructure, it's improving information towards abortion, infrastructure towards the health facilities these ladies are going to go to in regard to therapeutic abortion. In conclusion, the appellant prays that the Honorable Court, pursuant to Rule 31 of the Judicature Supreme Court rules, affirms the judgment of the First Trial Court and repeals the judgment of the Court of Appeal, but also awards cost to the appellant for both the High Court and the Court of Appeal. Much obliged.
No, you proceed. I'm giving you another 1 minute or two.
Okay.
Because of the questions that have come from this one.
Okay.
So you still have 2 minutes.
Okay.
You like want to ask? Oh, go ahead.
Okay. Much obliged, Your Lordship. Furthermore, to reiterate on my first head argument, we see that the state of Bokomo has placed policies, domestic laws, and to ensure the full realization to the right to health, which includes the right to sexual and reproductive health. Additionally, these policies have guaranteed, as earlier reiterated, as earlier stated, they guarantee when and how therapeutic abortion is accepted in the state of Bokomo. Furthermore, the state is not unwilling, the appellant is not unwilling to provide the right to health of its citizens in regard to non-therapeutic abortion. However, the state needs to cautiously approach the matter of non-therapeutic abortion in order to obtain harmony in the society, as I earlier stated. Because if we put away the harmony of the society, then how is the society of Bokomo going to...
It's like you're talking your own words without breaking the records. Can you restrict yourself to the state?
Much obliged. In the case of Webster versus Reproductive Health, 492 of the United States Supreme Court, 1986, it states that states have the interest to protect the potential life and may regulate abortion to further that interest. Your Lordships, in addition, the state has the duty to protect the life of the unborn child, and as such, the appellant is putting forward that in regarding the interest of both the right to life of the mother and the right to life of the unborn child, how the appellant needs to put forth to this honorable court that as a nation we can't ignore the life of the unborn child. In conclusion, the appellant prays that this honorable court, pursuant to Rule 31 of the Judicature Supreme Court rules, affirms the judgment of the First Trial Court and repeals the judgment of the Appeal Court. Much obliged.
I just had one question, just for clarity. You didn't tell us under what law are you bringing this case before this court? Under what law is this appeal before the court?
Much obliged. The rule that this honorable court is coming forward is Rule 41 of the Supreme, Rule 30 of the 41.
I'm actually not, my lord, bothered so much about it because he did mention it at the opening. And then for us here who think we are the Court of Appeal, we got shocked because when we looked at the issues, we actually apparently are the Supreme Court without even knowing. We thought we were reviewing a decision of the High Court. So the mix is not your fault. It's not their fault. Yes. I think because they've had a number of competitions and so on, this seems to be the Supreme Court. Yes. Although the problem question for us, we've been prepared to be the Court of Appeal or the Constitutional Court. So don't worry. We can give the floor to the respondents. There are many things that shocked us, for instance, to see the state appealing, because we are ready to hit the state.
Much obliged.
But we are trying to understand what is happening.
Much obliged.
So thank you. We can have the respondents take the floor.
Much obliged, Your Lordships. Once again, for the purpose of this court's record, my name is Nanyonja Shakira, appearing for the respondents. Your Lordships, this court has awarded us 20 minutes of its time, which we intend to use as follows. I shall use 12 minutes, in which I shall respond to the appellant's submissions under grounds 1 and ground 2 of the appeal. And my learned colleague, Tamale Ahmad, will use 8 minutes to respond to the appellant's submissions on grounds 3 of appeal while making the respondent's prayers.
Proceed.
Your Lordships, the rights to health and life are not mere obstructions. They are the very essence of human existence. And yet here comes the state of Bokomo that has utterly violated human rights. Yet it is the duty of every individual to ensure that human rights are protected, promoted, and upheld. Your Lordships, with the effect of the decision of the Court of Appeal of Bokomo, these human rights were upheld. And we appear before you, honorable justices, to persuade you not to be swayed by mere submissions, but to put into consideration the need to uphold human rights. Your Lordships, in regard to the ground 1 of appeal, we submit that the justices of the Court of Appeal of Bokomo did not err in law when they made a decision that the dismissal of Dr. Abeni was solely premised on her pregnancy, and hence she should be reinstated to her position as a surgeon with full benefit. Your Lordships, the appellants in their submissions allege that the dismissal was not premised on pregnancy because 1, it was lawful, and then 2, that Dr. Abeni had signed a contract with Saubona Hospital. And they also submitted that the reinstatement was not valid. Your Lordships, to start with their submissions on the lawfulness of their actions, they submitted that Dr. Abeni caused death of a patient. Your Lordships, the cause of the death of this patient was actually because Dr. Abeni had got pregnant and went for cesarean birth. But the hospital administration of Saubona denied her maternity leave and informed her that she cannot get the same because of the hospital's no marriage, no baby policy. Your Lordships, what do you expect a woman that has just given birth to do in theater? Dr. Abeni's health had deteriorated, including her mental health. And this explains why, as any other person, with the stress that comes with giving birth, Your Lordships, and she was a cesarean birth mother. As any other person, she only forgot to sterilize the equipment and led to the death of a patient. It is therefore clear that if the appellants, based on this, to dismiss Dr. Abeni, it is all rooted back to the fact that Dr. Abeni had got pregnant. They also submitted in regard to the contract that Dr. Abeni had signed with Saubona Hospital. Your Lordships, we submit that the contract involved the no marriage, no baby policy clause. And it is our submission that this clause, in much as Dr. Abeni had signed the contract, it does not withdraw the fact that this clause and this policy is discriminatory in nature. Your Lordships, why would a woman be denied the chance to have children? And why would a woman be denied the chance to get married? For any reason, she has the autonomy to make her own personal decisions in regard to her sexual and reproductive health, as was noted by the Committee on Economic, Social and Cultural Rights in its general comment number 22. It is also therefore evident that Dr. Abeni's violation of the hospital policy was because she got pregnant. Actually, if she had not got pregnant, Sawubona Hospital would not claim that she violated any policy. With that, Your Lordships, I cited the Committee on Economic, Social and Cultural Rights in its general comment number 22. Your Lordships, with all this evidence, it is very clear that the justices of the Court of Appeal made a good decision, and they were right to hold that the dismissal of Dr. Abeni was solely premised on her pregnancy. The appellants also submitted that Dr. Abeni could not be reinstated at Sawubona Hospital because her reinstatement was intolerable, and they submitted in regard to Section 70 of the Employment Act of Bokomo. Your Lordships, actually, the intolerable act that the appellants are alleging is the pregnancy. Yet the termination of employment conversion of 1982 has determined
the intolerable act is her uncouth behavior towards her superior. She was quarreling with her bosses and forcing the state to reinstate her would be contrary to the Employment Act.
Much obliged, my lord. My lord, it is true that Dr. Abeni had a verbal confrontation with her supervisor. But if you look at our evidence in paragraph 23, it clearly indicates that the dismissal was premised on pregnancy and not the verbal confrontation she had with her supervisor. The decision of the administration to have Dr. Abeni dismissed from Sawubona Hospital was because she made a decision, as any other woman, to get pregnant. And the hospital claims, together with the government, that this was violation of a policy. And the appellants also submitted in regard to religion that Sawubona Hospital is a religious hospital, and it maintains that they cannot have to provide abortions. Your Lordships, we submit that it is true that the right to religion is provided by the Constitution of Bokomo. However, Your Lordships, I persuade this honorable court with the jurisprudence in...
Counsel, just before you proceed, you talk about the aspect of being pregnant. Does that stop her from performing her part of the contract? For instance, the negligence in causing the death of a patient. Does her being pregnant exclude her from performing her duty as a medical doctor?
Much obliged, my lord. Being pregnant does not exclude her from performing her duties. However, Your Lordship, we note that Dr. Abeni had gotten a cesarean birth and she was entitled to get a maternity leave. Pursuant to Section 55 of the Employment Act, a maternity leave of 60 working days, but Sawubona Hospital denied the same to her and involved her in long working hours, surgical procedures. As a birth mother, what did they expect? Yet evidence clearly even reveals that her mental health had deteriorated. So the negligence maybe would have been there if it was different, that they granted her the maternity leave and she came back to work and that happened. But she was denied this, Your Lordships. With all the above evidence, we submit that the land justices of the Court of Appeal of Bokomo did not err in law in holding that the dismissal of Dr. Abeni was solely premised on her pregnancy, and that as such, she should be reinstated back as a surgeon with full-time benefit. I pray to proceed with the response to the appellant submission on ground 2 of appeal. In regard to this ground, the appellant submitted in regard to the principle of progressive realization of social, economic, and cultural rights. And they cited that actually the government of Bokomo has done enough in progressively realizing the right to health. Your Lordships, we submit that the government of Bokomo has not done enough to progressively realize the right to health. Your Lordships, the Supreme Court has pronounced itself in the case of Sehad and 3 others versus Attorney General, Constitutional Appeal number 1 of 2013, that states should not use the principle of progressive realization of social, economic, and cultural rights as an excuse for defeating and denying social, economic, and cultural rights. In the instant case, the right to health in Bokomo was defeated and was denied. And here comes the state and Saubona Hospital to argue that the state had done enough. They submitted that
Is the right to health a derogable right or non-derogable?
Much obliged, Your Lordship. The right to health is derogable. Your Lordships, they submitted that the government of Bokomo had done enough and that it had taken steps to progressively realize the right to health. They cited the step of taking steps for the development of the health sector of Bokomo. We submit that the government of Bokomo has not taken any steps for the development of the health sector of Bokomo. They argue that the bailing out of Saubona Hospital was an act for development. Yet the same Saubona Hospital is the one violating the citizens' right to health by denying them sexual and reproductive health care services. Your Lordships, we submit that the state of Bokomo has a core obligation at the very least minimum of its resources to ensure the satisfaction of the right to sexual and reproductive health, which includes measures to prevent unsafe abortions. The government of Bokomo decided to just criminalize abortions. And as such, women and girls in Bokomo still engage in acts of unsafe abortions. However, the appellants still alleged that this is entitled to protect the right to life. Yet the evidence in paragraph 29 indicates that as a result of criminalizing abortions in Bokomo, the state is faced with a high maternal mortality rate. Your Lordships,
Statistics cancer, because appellant's counsel gives very convincing statistics that it's just 7%.
While you look for the statistics, another issue I was expecting you to address, Koto, was the constructive dismissal. If somebody renegotiates your terms to make them less attractive, I would think that that would also be an issue that you would raise. Maybe you can address the court briefly.
much obliged, Your Lordship. The statistics, first of all, is that the state of Bokomo has 7 deaths per day. 7 women die every day in the state of Bokomo due to the criminalization of abortions. And in the constructive dismissal, Your Lordships, in as much as the state may allege that it was a second chance for Dr. Abeni, Your Lordships, as a result of all this, they put her to a position lower than the position she actually had and premised on her pregnancy. And this further explains why the land justices of the Court of Appeal of Bokomo made a decision that she should actually be reinstated to the position she had as a surgeon before the pregnancy and before the dismissal. Your Lordships, with regard to those 2 grounds of appeal, we are satisfied that the land justices of the Court of Appeal of Bokomo did not in any way err in law. unless this court has any indulgence with me. I so submit and seek leave to yield floor for my colleague Tamale Ahmad.
What indulgence are you referring to?
Thank you so much, Your Lordship. Unless this court has any inquiry for me in regard to my submissions. Thank you so much, Your Lordship. So I seek leave and yield floor for my colleague Tamale Ahmed to respond to the appellant's submissions on ground 3.
Much obliged, Your Lordships. Once again, appearing before you, I am Tamale Ahmad. I shall respond to the appellant's submissions on ground 3 and as well make our prayers within 8 minutes. Your Lordships, Your Lordships, the appellants have submitted that the land justices of the Constitutional Court are in law in holding that the failure of the government of Bokomo to put in place laws and policies for safe and legal termination of pregnancies has contributed to a high maternal mortality ratio. It is our submission. It is what the appellants alleged. In our submissions, Your Lordships.
Is that what they alleged?
Yes, my lord. Your Lordships, in response to their submissions, the appellants raised that the government of Bokomo cannot be solely attributed to the high maternal mortality ratio in Bokomo. And to respond on that, we shall respond that the government of Bokomo has a duty to protect and promote fundamental human rights as it is enshrined under Article 20 of the Constitution of Bokomo. Your Lordships, in our submission, there are many ways the government can protect fundamental human rights, and including the government can enact laws to prohibit acts that violate human rights. And we proceed that the government of Bokomo, pursuant to Article 79 of the Constitution of Bokomo, is entitled to make laws for order and peace and good governance of Bokomo. Your Lordships, if I may refer you to our facts, evidence in facts, the Republic of Bokomo criminalized abortions, and it failed to enact any other law to decriminalize it. And my lords, Article 29 of the facts, evidence in facts, clearly reveals that the failure of the government of Bokomo to enact a law that guarantees safe and legal termination of pregnancies has resulted into a high maternal mortality ratio in the country. Your Lordships, the statistics show that Bokomo is experiencing 362 days per 100,000 live births.
Just a moment. What are you saying about that statistic?
Statistics show that Bokomo is experiencing 362 deaths per 162 per 100,000 live births. And it also indicates that 2,600 women and girls die annually. And this is attributed to 7 deaths a day. Your Lordships, it is our submission as the respondents that criminal regulations on abortions actually serves a non-known deterrent value. And this is because even with restricted access to abortions, women often engaged in clandestine abortions. And an example to be inclusive is Dr. Abeni, who engaged in obtaining abortifacients that endangered her health and led her and which affected her life. My lords, yes, my lord. Your Lordships, much obliged, Your Lordship, I pray to respond that case by persuading this honorable court with the jurisprudence in Raylons versus US. My lords, the US Supreme Court made a precedent that while guaranteeing a practice of a religious obligation, the government is entitled to limit this practice when it is realizing and observing health, life, and welfare of the citizens. And the government of Bokomo has failed to make laws and policies irrespective of the religion in Bokomo. Your Lordships, the appellants have also raised that the government of Bokomo has issued the national policy guidelines. And to respond on this, my lords, the national policy guidelines, we agree that they are issued. But however, these policies are so specific and they are discriminative. This is because they are only applied to specific categories of people. Your Lordship, they are raised that the government did this because it was protecting a right to life. My lords, and this imposes a question that is it that Dr. Abeni was not entitled to be her life to be protected because she was not guaranteed abortions in the policy guidelines? Because actually these guidelines did not provide for people in her category. And the government are trying to escape liability that they made laws. It is on this note that we submit that the government of Bokomo should put in place a policy and a law that decriminalize abortion and a law that guarantees safe and legal abortions. Your Lordships,
In other words, you're saying that they have made an empty claim that they make laws when there's a very crucial issue that has not been legislated.
much obliged, Your Lordship, that is it.
And that is decriminalizing abortion.
Yes, Your Lordship.
Thank you so much.
Just to add to that, wouldn't that be violating the right to life?
Yes.
Decriminalizing abortion, doesn't it violate the right to life?
Much obliged, Your Lordship. I move to answer that question pursuant to the jurisprudence in X versus the Principal Secretary, Family and Welfare Department, where the Supreme...
Case is from where?
It is the case of 2023 in the Supreme Court of India.
Go ahead.
Your Lordships, in this case, it was observed that laws that criminalize abortions deny women sexual and reproductive health autonomy, and it emphasized that every pregnant woman is entitled to sexual and reproductive health, and these rights include abortions. And the same emphasized that these laws should be decriminalized. The abortion should be decriminalized. It is in our submission that this court may be persuaded by the decisions of that court to order the government of Bokomo to enact a law that decriminalizes abortions. Much obliged, Your Lordships. If it may please you, my lords, I pray to proceed and make our prayers.
You go ahead because you have passed the time.
Much obliged.
I'm giving you 1 minute.
Much obliged, Your Lordships. Your Lordships, it is in our aspirations that health and other human rights are finally sought and recognized as rights that are not merely pleaded for, but as rights that should be enforced in Bokomo. And Your Lordships, we emphasize that in countries like Bokomo, a right to life, a right to health, and a right to fair and equal treatment should be recognized and enforced
because of their value. Your Lordships, the justices of the Constitutional Court recognized the fundamental human rights, and this is reflected in their decisions. And we move forward to pray that this Honorable Court confirms their decisions in order that people of Bokomo, specifically the vulnerable people, including Dr. Abeni and other people, have a right to human rights. And we also pray that this Honorable Court, and we also submit that in our submission, we were able to prove and lightened that the justices of the Court of Appeal did not in any way err in law in making a holding that the failure of the government of Bokomo to put in place laws and policies for safe and legal termination of pregnancies has contributed to a high maternal mortality ratio in the country. If it may please you, my lords, I so pray and submit.
Thank you very much. Can we have the appellant rejoin? And your 5 minutes start now.
Much obliged, Your Lordships. Your Lordships, the respondents seem to have misunderstood the no marriage, no pregnancy policy. The appellants submit that the no marriage, no pregnancy policy does not mean that you will not get married, you will not get pregnant. This policy means that if you are not married, you are not allowed to have a pregnancy at Saubona Hospital. This policy stems from the religious doctrine that the hospital follows, Your Lordships. And the appellants submit that this hospital, being a religious hospital, has the right to enact policies that are in line with its religious doctrine. Your Lordships, the respondents have submitted that the reinstatement was valid on the basis that the dismissal was unfair. As I earlier submitted, that even in the event that this Honorable Court decides to agree with the Court of Appeal that the dismissal was unfair, reinstatement still could not be granted to Dr. Abeni, Your Lordships. I stated that because unfair dismissal falls under the exceptions of the Employment Act when reinstatement cannot be granted, Your Lordships. Your Lordships, the respondent submitted that the state has said it has done.
What should the person get in lieu?
Much obliged, Your Lordship. If the dismissal was indeed unfair, the Dr. Abeni would have been entitled to payment in lieu of notice, Your Lordship.
No, she has been reinstated, but the law says she cannot be reinstated because of a bad working relationship that will ensue. So in lieu of that reinstatement, what do you propose the court can now direct or order?
Much obliged, Your Lordship.
If it finds that indeed the dismissal was not fair, or if it agrees with the decision of the Court of Appeal.
Much obliged, Your Lordship. This Honorable Court can grant Dr. Abeni damages if it feels that indeed her dismissal was unfair. Your Lordship, the respondent submitted that the state says it has done enough. We did not say we have done enough. We say that we are taking steps and we're doing what we can within the resources that are available, Your Lordships. This is a third world country, and we are taking the steps necessary within the resources that are available to ensure that the right to health is recognized in the state of Bokomo. I submitted that the state bailed out Saubona Hospital when it was facing financial challenges, Your Lordships. This shows that we are taking the steps within what we have to ensure that this right is indeed recognized. Your Lordships, the respondents also submitted that the maternal mortality ratio is solely as a result.
I have not heard you say anything about the denial of maternity leave.
Much obliged, Your Lordships.
The person who has actually produced the child, whether illegally or legally.
Much obliged.
And physically, any medical establishment should know that the person is drained.
Much
Are you still justifying
Much obliged, your lords.
Because of the contract that she signed that I'll never be pregnant until I get married?
Much obliged, your lordships. The appellants do concede that we did not, in fact, grant Dr. Abeni maternity leave. However, in any event, Dr. Abeni still led to the death of a patient, your lordships. This patient...
The argument of the opposite party is that the cause of death or the death resulted from failure to give her leave. She was not in the best physical and mental state to stand in a surgical ward for long.
Much obliged, your lordship. As I stated, we do concede that we did not grant Dr. Abeni as maternal leave. However, we submit that this should not serve as a justification for her leading to the death of the patient, your lordship.
You don't know that when women give birth, they suffer from mental stress?
Much obliged.
That even the penal code, if a woman killed her child at that moment, would not allow her to be charged with murder. A woman delivers a child and strangles the child. The law says that she's not guilty of murder, but another offense. So in this case, a mother had delivered, had not been given maternity leave, which you concede was wrong, and has started acting like someone who is mentally ill. You still give her the responsibility for killing a person. You are insisting, counsel.
Much obliged, your lordship. I am guided. Yes, a pregnant mother after pregnancy does experience some mental challenges. However, we still submit that the death of the patient should not be excused, your lordship.
Thank you.
Much obliged, your lordship. Additionally, the respondent argues that the maternal mortality ratio is solely as a cause of the criminalization of abortion. However, my co-counsel submitted that this maternal mortality ratio is also as a result of other factors that actually contribute a higher percentage to this maternal mortality ratio. Criminalization of abortion contributes 7.2%. The appellants are not saying that this 7.2% is small. Yes, these are lives that have been lost. These are valuable lives that have been lost. However, the assertion that this maternal mortality ratio is contributed by the criminalization of abortion, the appellants submit is wrong, your lordship. Your lordships, the respondents also submitted that the state of Bokomo has criminalized abortion and not enacted any laws that allow for abortion. Your lordships, we do submit that yes, we have criminalized abortion. However, in exceptional circumstances under the Ministry of Health guidelines on the provision of sexual and reproductive health, in these exceptional circumstances, a pregnant mother can be provided with abortion services in the event that her life is at risk, your lordships. As I stated in my opening statement, this court is faced with a question of balancing the right to health of the pregnant mother and the right to life of the unborn child, who unfortunately cannot speak for itself. Your lordship, these exceptions create this balance, in that in the event that the life of the mother is at risk, then an abortion can be procured. But if the life of the mother is not at risk, then we shall save the right to life of the unborn child, your lordships.
How is that assessed?
Much obliged, your lordships.
The mother is at risk, the mother is not at risk.
Much
Are there any guidelines on assessment?
Much obliged, your lordships. The guidelines do include guidelines on assessments that include instances where there are conditions that a pregnant mother must be going through for one to say that her life is at risk, your lordship. And if she's not going through these instances, then her life is not at risk and the doctor shall proceed to protect the life of the unborn child, your lordship. Much obliged, your lordship. My co-counsel mentioned the conditions. Your lordships.
Excuse me, counsel.
Remember, here, I only had the exceptions to abortion, but this question is specific about assessment of whether the mother is in danger if the abortion continues.
the doctor in charge does that assessment. In the record of appeal, we see that Dr. Coker did this assessment, and when he found out that it was an induced termination of pregnancy, he decided not to give abortion.
Even when there was a danger that the child might not be a normal child.
Your Lordship, even in this danger that the child might not be a normal child, it is only when the child might not survive when a mother can procure an abortion. But in the instant case, yes, the child will be born with complications. However, the child would be able to live, Your Lordship.
Even when the child doesn't know that they are living. That's what you are saying.
Yes.
How far the law has gone.
Yes, Your Lordship.
Thank you so much.
Much, much obliged, Your Lordship. It is on this basis that the appellants pray that this honorable court confirms the judgment of the trial court and sets aside the judgment of a court of appeal in holding that the actions of the respondent did not violate Dr. Abeni's right to health, her dismissal was not unlawful, and that the numbers indicated did not contribute to the high maternal mortality ratio, Your Lordships. If I may be of no further assistance to this honorable court, I beg to submit.
Are we expected to make our determination or to recess? We've not been advised. Your Lordship, can you come behind and you teach the children the right thing of how we proceed in final court? We come here opposite where we go back.
Colleagues, good morning. Please don't go. For those that have not been part of the moot, we usually allow the judges to write the judgment so that they come back to do to give you the judgment, right? So in the meantime, I'm not sure if the breakfast is still there, but those that didn't have breakfast, please proceed to have. They will not spend a lot of time there. But the moment we release students, you take time to come back and then we delay to get the judgments. So we are going to kindly request that you can have the break tea if you didn't and you're entitled to it. And then others can stay around to network as we wait for the judges. Trust me, they'll be here in the next 10 or 15 minutes. Thank you. Also, we'll have engagements after this, after the judges. So when we get the judgment, we'll be so happy. Please don't go because we have to award the winning teams, but also those that did participate yesterday. Yeah? So you don't go away. You wait for that session to be completed. Thank you.
The court was in session. Kindly just move out and go and get some tea.
So the court is back in session, not to give the judgment, but to, I think you already know the judgment from the questions, but to make some observations on the performance of the mooters, and each of us will give a comment before we announce the winner. I'll ask Lord Justice Okumu to begin.
Thank you, my Lord, the head of the panel. I want to take this opportunity to thank all of you for participating in this case. I had the opportunity to share my decision with the panelists and the decision of the head of this panel, with whom I totally agree with her decision. I just have one comment to make on how we started our presentations. But before I do that, I would also want to appreciate the head of the panel. He was too lenient, she was too good, and she guided this case very well. If I was the head, it would have been the opposite, because I would frame the question and I throw it to you and you look for where to find the answer. But for her, she could go ahead and guide and bring you back to where the case is. I only want to talk about the introduction. The presentation was too good. But this is an appeal which started from High Court, went to Court of Appeal, and came to Supreme Court. The Supreme Court doesn't know the background of this case at all. It would be prudent for the counsel, for the appellant, to make a good background introduction of the case. Start by telling us what this case is. Where does it started? What was the course of action? What did the court, High Court, try? Why did you agree with the decision of the High Court and you went to Court of Appeal? How did the Court of Appeal decide, which make you to disagree with them and you come to Supreme Court? With there, you would have persuaded the judges on what your case is. But basically, the presentation was good. This was a human rights case. You all did well. And it was specific on the gender and equity, which you have to look for your own knowledge. You look at the laws, which are biased. You look at the administrative laws. How are they, the institution administering the law? How you brought in the Beni Hospital. And then you look at the communities where we live, how they perceive this. The state, I saw all of you did well. You brought in the state, it's a religious state. And you try to show us these are religious people, whereby they don't accept, if you are not officially married, they will not accept you to get pregnant and bear a child in order to work in their hospital. All those aspects are good. And then later on you go and back up with the law and find out whether it's a good practice or bad practice. That is the only comment I wanted to put there. However, I want to thank you very much. You did a good research. You knew your case. You knew the law. And keep that up. I swear when you do that and you come to me, when your case is bad or good, you will win it. Thank you very much.
Thank you. Thank you, Chair. I have general question, rather general comments. Prepared. Everybody, every council looked prepared. And once you are prepared, everything will flow. That's when we noticed that even when you are bombarded with questions, you were ready to answer there and then. It showed the preparation. Even the way you had put the stickers, it was very clear. You had something to say other than keeping quiet. So I say always prepare and prepare and prepare. And you were very stable. Despite interruptions with these questions, you remained stable. And you were audible. Some people, when it comes to coaches, like they talk on the table, even the litigants behind are not hearing what they are saying. And these people want to listen. They are full in that court, they want to listen. So you were audible enough, and we heard you properly. When commenting on these treaties, we know that the states signed these international treaties, but when commenting on them, I would wish that even we try to show how have they domesticated these treaties in our country, so that we relate to the facts that we have. Yes, the treaties are there internationally, but how do they apply to us? What are the circumstances that we have? So when we cite those treaties, let's bring it back. Even when we are looking at the constitutional provisions, because the Constitution is a framework, it just gives us a frame. But what are the enabling laws that are in line with those articles? You go ahead and look for those laws that will enable that article to be enforced. And maybe generally, we had a lecturer who used to tell us that when you are looking at your case, don't stop there. First look at your case, then turn and say, if I were on the other side, what was I supposed to? What would I have said? Then you also look at the other side. So when you do that, you look at the case on both sides, you find that you will always be ready to answer anything. Thank you so much. Well done, everybody.
Thank you, my Lord Chair.
Thank you very much, Chair. I just have about 2 comments. In other words, the presentation was excellent. Everything was on point. There was adequate preparation from all the counsel of both sides. But my comment is in respect to the laws that are cited. When you're citing these laws, please ensure you quote the supreme law of the land first. Then you can follow up with all the other laws. Then the international laws, how they persuade, then case law. That is very important. And then the next comment was in respect to demeanor. Demeanor was excellent. Eye contact was excellent. Tone of voice, everything was good. Thank you very much.
Thank you. Just to add on what the rest have already said, to avoid repetition, I will just be brief about my comment on preparation. The preparation was excellent. It shone through from the way you presented yourself, the confidence. Good preparation automatically results in confidence. There was no fumbling, there was no mumbling, there were no awkward pauses. You prepared and you came ready to do your best. And it shone through. Thank you for the preparation. We're just discussing among ourselves how sometimes we get counsel in our courts and they haven't prepared. They are preparing there as the case is going to start. But in your case, we could see that you had taken this matter seriously and you had put in time. And that time spoke for itself. It came out in your presentations and in the way you held yourself. To add on the issue of the Constitution, it would have been good to see the nexus between the Constitution and those other provisions in the other laws that you quoted, and a little bit of what happens when there is a clash between the constitutional provisions and the provisions that are there in the subordinate law. Thank you. Well done. Keep it up, and when you go into practice, please remember, preparation is key. Prepare, consult, and come to court ready to shine as you've shown today. Congratulations.
Thank you so much. I wish to agree with the land panelists on the comments that they have made regarding the performance of the two sides. I think I first want to say, in agreement, of course, I don't want to regurgitate what they have said. I do agree entirely. But what I saw in terms of generally, and this is general, that I didn't feel like the state put up a strong argument. I don't know whether you know the facts too much that you already knew that the judgment was going to be against you. But that is not what state attorneys working for the government of Uganda do. They really argue this case to the last man. Ridiculous arguments sometimes. But they come with a lot of confidence. And I'm also speaking because I have ever been a state attorney. Although my practice was in criminal law, together with my colleague on the other side. We were prosecutors. But there was no bad case before us. And I think before Okumu here, his lordship would have won all our cases. Because he has said, if you come with that confidence, you are likely to even mislead him and he makes a very different decision. So that's the general position, that you should put up as an advocate. If you really believe in your things, put up your case. But the other thing is, if the court tries to guide you to see an obvious problem, you should concede. Don't try to only concede on, and I'm telling you, if you really practice, I think you have gone to the Supreme Court as a lawyer, a practitioner, and I know she has, I have. It's not a joking place. It's not a place for talking anyhow either. You must concede what you have to concede. If you don't move forward. They will just put down the pens, refuse to write. There's a very ridiculous thing you're talking about, and the court is guiding you, and you are insisting. So when you really see the point, concede it, and only insist on, because you can't win on everything. You might win on one or two things. You might have a very clear pronouncement. You've not won, but a very clear pronouncement on rights. For instance, maybe your issue on abortion, you could have some wins and some losses on some issues. So look at, for those issues where you know, this one, even they are not yet ready to overturn the law. But on this one of a person almost dying, no maternity leave, an abortion that has almost happened, and you insist upon, keep the child, go to work. That is so inhuman. And you cannot be seen standing as a defender of the Constitution to support it. I also saw a lot of attempts to use the Queen's language, which is now considered archaic, unpalatable, retrogressive. Did you read The Lion and the Jewel? You know those terms by Lakunle. Excommunicated, archaic. If you haven't, please go and read the Lion and the Jewel. It is very interesting for all of us. So much obliged should be rarely used. You can use simple words. Thank you. Thanks for the guidance. And that kind of things. We rest our case and blah, blah. Just be simple. When I was at LDC, and that was in 1994, yes, we were stopped from using those words. That is when Latin died. It was in the system before that. And I know most of you, if I ask you what is nulla poena sine lege, nullum crinum sine lege, you don't know. Because Latin was killed. So don't try to waste your time with lingua, syntax and semantics. Use simple words that make the court to understand the case. I wish to congratulate all the mooters Congratulations. You've done a tremendous job. I think you have these skills, argumentation skills, clarity, coherence, persuasiveness. You know the law. You analyze the case properly. Your responsiveness to questions was very good, as has been said. Your replies to the challenges raised by the other parties were very good. Confidence. If I had the power, I would give you 100%, all of you. You were very confident. May you keep your confidence, even when the time comes now outside school. Communication, you were very clear in your communication. Time management, very good. We didn't have enough time but we assumed there was a lot of teamwork in your work. We felt respected. I think the dress code is very good, although your flaps are not starched and straight. I don't know whether they are Boroboro High School PO box return to the sender. So I think you did a perfect job in your presentations. I don't want to read everybody's assessments, but I think that you did a good job in legal arguments, presentation. You almost equaled from my personal evaluation. You all were very persuasive, although I wished you were more persuasive than you were, and I also wished you had admitted certain positions. So having said that, am I free to now announce? I am. I'll start with individual performance. Adrian scored 78.6. Gloria scored 67. Shakira scored 84. Tamale scored 72. And that takes me back to my warning that with moots, it's not necessarily the rightfulness of your cause that matters. What matters? And you know, you might be conflicted. And in real life, when you're conflicted, you recuse yourself. But even if you are conflicted, you are fighting a battle here. So notwithstanding the weakness of your case, always insist on doing the best you can. And generally, these are the scores. The appellants got 72.8. And the respondents got 78.2. And I thought there should have been clapping for even the respondents. Because as far as we are concerned, the teams all did very well. The best oralist for the 11th CIHAD Annual Constitutional Law Moot Competition, Shakira Nanyunga. And that was because she reminded myself of me. But I didn't give the final mark. Everybody silently gave her the mark. At the end of the day, she wins. Confidence. You all had confidence, but she went a little bit further in discussing the respondent's case. She was very much more clearer on what their case looked like, on what was wrong with the appellant's case and submissions. She properly divided the case. I don't know whether it was the problem of time that my dear brother Ahmad did not take it. But I can tell you, from this side, we saw that your side generally did a good job. A great job. But on general terms, all the mooters did a perfect job and performed better than many lawyers that appear before us on a day-to-day basis. So if you keep this up, I can tell you your practice is going to maybe be better than for most of us. Thank you so much. I wanted to ask that we take a picture here with the mooters and maybe the leadership of Sehad. Just where we are, stand behind us. And we take that picture and remember it for the years to come.
CLMM coordinator. CLMM coordinator. Come for a picture. You're the ones there.
I want to thank your lecturers and Sehad for their efforts in mobilizing you and in organizing this moot. I know that your teachers played a very big role. Can you thank them for me? Clap for them. And thank you so much, Sehad, for always, first of all, for this initiative that introduces human rights, just a moment, and the human rights of women, and generally sexual and reproductive health rights into the curriculum and the agenda of students while they are still at school. Of course, we feel flattered that you have invited us to be judges in this moot. Asanteni sana. Where's the court clerk? He has retired.
We have come to the almost the end of the moot competition, and for the next session, I don't think I have the power to take over it. So, but we are going to the award process to recognize and award our winners and the first runner-up. And it's at this point that I invite the executive director of SEHAD to come and do the honors of inviting the judges, and we do that award ceremony. Miss Fatia, you're very welcome to take over the next session.
Thank you so much, colleague Esther, for getting us to this point. Our dear judges, we thank you so much for presiding over the Moot, the 2024 Moot. And for some of you, this is not the first time. We appreciate you sincerely because you have seen the value of nurturing and inspiring the young lawyers. And for our dear ones who are, this is the first time, I think you have also seen that this is one way we can connect the classroom and what is out of the classroom in terms of supporting our communities and in terms of making the legal profession relevant to the communities. So we thank you very much for accepting to preside over this important Moot. And also in absentia, the magistrates who presided over yesterday for the preliminaries. We are grateful to them. We appreciate you and the entire judiciary of Uganda for accepting to extend your knowledge to the upcoming lawyers and advocates of this country. And the magistrates in absentia also for yesterday. We are grateful for the time you have taken to listen to the student presentations and submissions and the guidance you have provided them to build their career. So I'll say more later, but at this point in time, I would like to invite you to present awards to the winners and to the participants of this 2024 Moot. I humbly request. Yes.
Give the medals, just invite them, the winners. These are for the winners, the gold.
All right, thank you so much, colleagues, and thank you for that day. So we'll have the best motors for the day. The winning team receive their medals. Shakira and your colleague. The gold medals are for the winning team and the silver. If I were you, I would clap for these colleagues. And the silver medals, for the first runner-up. Please, when you come here, feel free to take a minute for your photo, right? Okay. So, since yesterday, we don't know the teams mooting. They have had codes, we had CLMs, and I think it is just fair that we mention the colleagues that were before you here. we had Islamic University in Uganda, Mbale campus. Against, we also had Cavendish University, and the team that took over the 11th Moot today has been IU Mbale, and we want to congratulate them. Colleagues, IU Mbale, thank you. We would continue clapping. Aren't you happy? Ngami, I'm happy. Congratulations, IU Mbale. And the first runner-up. The Mooters still need a photo. Great. So where are the smiles for that winning team? Okay, the first runners up. So this will be presented to Cavendish University. What was the code? CLMH. I love the way we are making it, yeah? Please continue so that we give the energy. Congratulations, Cavendish University. You really did your best. So where are the smiles? All right, congratulations to the teams that are winning. So these students have only been able to present before you, dear judges, because they've had teams coordinating them, and it is just fair that we also appreciate the teams that have been coordinating them. We are also aware that 2 of our judges will leave at 12:30, yet we need a group photo at the stairs for our record. So we are going to do the awarding of the of the coordinators, and then we go and do a group photo. Then the students will come back and request that we will do awarding, even if the judges are not here, if you so wish. Thank you so much. So we'll just do our coordinators, yeah? So Muchibi Sharif. I'm not sure which university, so just give them. They're just a few. IU. Nachirai Fatuma, IU Kampala. Idi. Nimsima Brighton, Uganda Pentecostal. Iranga Godfrey, Cavendish. Joel Jerry Walyono, IUEA. Joel Jerry, International University of East Africa. Mukabire Moses, International University, Islamic University in Uganda, Mbale campus. I am reminded that the winners of the Moot today. Atai Isabel Nicole, Makerere University. Kisache Joel, Israel, Uganda Christian University, Mukono. Yes. Lake Gender Francie. Fancy. Sorry. Gulu University. Eric Habu, Uganda Pentecostal University. Fort Portal. Yes. Raymond is for who? Anguzu Raymond, Kampala International University. Kampala International University. Jocelyn is which university? Nasamba Jocelyn Latisha. Which university is this? Nkumba? Nasamba Jocelyn. I'm not sure about the university. Nkumba University. And lastly, Mary Flavia Nakamate from King Caesar University. So in total, we had 13 participating universities. We really want to appreciate you so much, King Caesar, for making time. Yes, for making time. We have certificates that we have to give out later. So we will request that you actually do the photo with the judges because you want it. We usually do the photo on the stairs towards the pool. So we just go out, move down on the stairs, arrange ourselves, the judges will come, we take a photo, and then we come back to receive our certificates. Please don't leave your certificate here. Having said that, I think it's also an honor to award the judges. They have made time for us. They have put court business on hold. We really want to appreciate them so much for making time. And we'll just take the honor to read out the names and then hand over to the ED. So we'll start with Honorable Lady Justice Susan Okalan. Thank you so much for making time. Honorable Lady Justice Rosette Comfort Kanya. Thank you so much. Honorable Lady Justice Aisha Naluze Batala, we appreciate your time. His Worship Okum Jude Mone, we really appreciate your time. And Her Worship Edimo Helen, we really thank you so much. So allow me to invite the SEHAD staff to first take your photo with the judges here. Then we can take our photo with everyone down. SEHAD staff, you only have a minute to be here. SEHAD staff? Where are we? Please hurry up. Okay. Can you move that table? You will fit? Okay. All right, so shall we have all the staff behind the judges, please? Unless if you feel we won't fit. Do we have all the staff here? We assume that somebody is looking at property there and that property will not be stolen. All right, we'll take a minute. After here, we'll request that you please sit down, wait for the judges to go out, then you can come and meet them outside. All of us. Where are the smiles? All right, so we are going to request that we allow the judges to go first. Property has to be kept here. Faith, can I have someone remain in the room? We're leaving everything here, and you're still here? Okay, thank you. So we'll lead the judges out, retaining everyone, and then others will follow us when the judges go out. Idi, kindly. Okay. When we got the stairs, please don't fight to be seen in the photo. You'll be seen. In fact, the person who will be exactly at the last stair will be seen faster than the one on the one below. So we'll have the judges down, and then when you come, you just follow behind, yeah? When we finish the photos, please come back, because I know it's also getting to lunchtime and we have lunch. We'll award so your transport and getting out of the room, yeah? So we'll allow the judges to go out, and then we follow. So you follow after me. Thank you. The universities. So the universities are not in order, but the students are here, and the names are not in order. When I read your name, you kindly come. So Aye Baziwe, Hilary. Isingoma Alan Jack. If the person is not here, you let us know. So I'm going to request that we first sit. Okay. The camera people are not yet here. I'm not sure why. Faith, Jackie, Faith, Jackie. We need some photos here. So because we are many, when we take the certificates, we first sit, then we'll come back and take a photo with our lecturers. Are we comfortable that we have a camera person in the room now? Jackie and Faith? So Hilary and who? Jackie? Isingoma, kindly come back for your photos, yeah? We have to update our statuses, so we are sorry. As a Gen Z, yeah? Please ask Dafa for your photos, yeah? Great, thank you. I also understand the motors are on our WhatsApp group, so they can get the link for the photos and share with the universities. Okay, Ogwondo Constant Alari. Constant? Please be in the middle and take your photo. Nanyonja Shakira. Nanyonja Shakira. Mwendwa Grace. Grace as number for prepares. Andrew. Nambafu Andrew Buyinga. But the people coming are not smiling. Over Mubadechi. Atrinda Shidra, please prepare. Sorry. But you come with a smile. You people have one life to live. Why aren't you happy when you still have a life? They are so sad. Wow. Senor, prepare. Senor Joseph Michael. Who prepares? A team, Catherine Hope, prepare. A team, Catherine. No, we'll take the best oralist. Yes, darling. Yes, you are so good.
They're planning.
I love it. Simon Peter Hewa. Namudu, prepare. The camera people are saying pause. Hey, they didn't take your photo, sir. Excuse me? They didn't take your photo. Meanwhile, Nafka Christian, prepare. But can anyone come and pose for Namudu's photo? Daniela, come and pose as Namudu Winnie. Where's Daniela? Later, Namudu Winnie. Nafka Christine, are you preparing? Why am I not the Namudu, but you are lecturer advisor? Great, Nafka Christine. Meanwhile, Moyo, Rutendo, prepare. Moyo, where are we? Moyo, Rutendo, as Kauthara Dawood prepares. Kauthar Dawood Gulam. Tongire Rona. Rona. Meanwhile, Tamale Ahmed, prepare. Tamale, where are you? Start moving. Tamale is not here. Let end. Gloria Edith. Okay. Gloria. Banange, clap for Gloria. Gloria, someone is saying they're taking you on for internship. Please take note of the face. Masolo Adrian. Akelo Fielder, please prepare. Can someone come and pose for Akelo? Dangerous substitute for Akelo Fielder, please come. Agava Faith. As Namu Nuamanya Angel prepares, Angel, as Orange Simon Peter, you prepare. Orange Simon Peter. Busura Abdul Karim, please prepare. But the level of discrimination in this room, Discrimination is not allowed here. Karim, why is it that people are clapping for you? Eh? He's famous. Muntu wafe. Okay. Okay, let me see if you'll also clap for Atmango, Mercy Fortunate. Mercy, where are you? Rukundo, Roland. Dala, why do you discriminate? Aish. No. As Nkalubo Opera. Okay, Tamale Ahmad is, I think, taking an interview, as well as Nanyonja Shakira. So they will pick their certificates. In the meantime, thank you so much. You can take your seat so that we do the closing bit of it. In the meantime, allow me to take the opportunity to appreciate so much the colleagues that have worked extremely hard to see that this Moot takes precedent. The Moot is housed in our strategic litigation department, to which we have the manager here. Ruth, please come up. Ruth is the manager of our strategic litigation department, and it is just fair that you see the lawyers behind the cases you've read. So the lawyers behind the cases, colleagues from the strategic litigation department, Esther, Rodney, Bako, Rit, Achola, Faith, who else? Mwedu, are you here? He's gone somewhere. So these colleagues are the mastermind behind the Moot. The Moot is housed in our strategic litigation department. All these are advocates of the High Court and all courts of judicature. So you can take the opportunity to speak to them and see how we conceptualize cases that we take to court. It's rare that we come to a Moot and you don't cite as a hard case. It is very rare. This is the 11th Moot. For the last 10 Moots, the only cases that students have cited here have been cases from SEHAD. So really want to appreciate you. And don't go. So beyond the litigation team, we have had one coordinating the judges, Saith, you're part of us for the Toyamba Desati. So Saith has been coordinating all the judges that you saw here. And we really want to appreciate him. He's from our campaigns, partnerships, and networks department. So he was networking for us. He graduated from the litigation department and went to the other department. Are you looking for me? Okay. Thank you. So beyond the litigation team, it's just fair that you come here and appreciate your other colleagues, Vambi. SL team, please come back and we appreciate other colleagues. So we had someone that led us to the Tally Center who was seated there, and we kept telling her, please, Tokakwatam, record as it has come. And that person is our head of HR, Human Resource and Admin, the one and only Florence Nakanoaji. She's our HR. She's been doing the tallying and ensuring that you get the results, and we really appreciate her. Beyond that, Flowy, we need a photo with you, ma'am. And people are saying, oh, how does she look like? Is she part of SEAD? Yes, she's part of us. And then we've had someone who I'm not sure she will leave, but from our finance department, the money person. We have the money director here, Miss Namsoke, our director of finance, Naomi. We saw you somewhere. Please join us. But Naomi moved with the money person that was supporting us yesterday, Immaculate Bukira. I'm sure she's seated on our booth. We all know her. At least we've signed with her, so we know her. So Naomi leads our finance team. So we also have the community empowerment program. Now people are saying, I see had cousin Kole. I see them in Labatong. Is it called Labatong? Aleptong. I see them in Hoima. I see them in what? The person is coming meanwhile. So Gwang, join us. I saw him in West Nile. He was in Gulu. He was in Arua. He was in Bale. He was in Yumbe. He was the person behind the movement of those cars is him. So he works in our community empowerment program. Ogwang Christopher, where we get the cases that we form the moot problems that we've been mooting today. Where we get the cases that the litigation department takes to court. Where we get the cases that the advocacy team opts to speak about. Beyond this, we have heads of these departments. I'm not sure if yes, I am not sure if Richard is here. Muganzi, he had a glitch yesterday with a son, I think a daughter, might not be here. But all these things have been online. Bukira, you can join us. She's watching her things, okay. So behind all this, I've been watching on X Spaces and saying, I love this photo of the, what's her name? Nanyonja? Shakira. There's a photo where she's making a point on X Space and I was like, I love this photo. So we have had you have the full communications department of SEHAD here. Do not expect very fat people, but you'll see the team behind, the young people. So Jackie and Faith, please join us. Now someone's going to say, those guys, I think yesterday the judges said, you people are so known everywhere. They're behind our publicity, they're behind our visibility. So I say don't expect fat people, but our brains are in there. And these guys are supervised by our Director of Business Development, the mastermind behind those items we are selling to you. So Phil, please join us. So I really thought that I would introduce the team. We rarely don't introduce our team, but it's important that you know the people behind us. Our Executive Director is with the communications team. We are a team of 51. So this is just bits and pieces of us. Most of us are in the field. We are a team of 51, but we really, really honor your time and appreciate you for making this moot a success. So I called upon the team to just appreciate them. My position is just Deputy Executive Director, but we also have the Executive Director. So I really want to appreciate us here, but also those that are not here. So at SEHAD, we usually award the best oralist with an internship placement, fully supported, of 3 months. 3 months. So Nanyonja, is she called Nanyonja? Shakira, you hereby have been awarded 3 months internship placement at SEHAD, effective 2025. Please, you will have to coordinate with the team to just let us know when your schedule allows. In the 3 months, what the students do is to be treated as a SEHAD staff. Where is Jay? Jay has just completed his, okay, Jay is from UPU Kampala. I think he was our best oralist last year. I've also seen here, Calvin. Yes. I saw Calvin here. So what they do is that when you come into SEHAD, you are treated like a staff. For us, we don't have those things of mentoring. We expect the skills you have applied here to apply them at work. So when you come and they tell you, conceptualize a case, we expect you to read all those things and put a case together. You learn, you network, you negotiate, you do everything. You go to the field, you're treated like staff. So the internship comes with all these other things. We only take on one person because we are too many and we only have space for one person, but we really, really loved the way people are presenting here and in other rooms. At least each of us has been pointing to that one person to say we want to take on this. So Shakira, for whenever you're ready, it is only for 1 year. If 2025 goes, it means you don't have the placement, because then we'll be bringing in or ushering in another best oralist for next year. So until October 2025, your placement is available at SEHAD. Our offices are just in one place, Nakweru. So be sure to move from Mbale to Gaza Road, Nakweru. We wish you the best, but in the meantime, I'm going to allow the team to please hand over the certificate to you. And since we had the HR here and the manager of SL, kindly take on the mantle and hand over the certificate. We congratulate you, Shakira. Can we also have Tamale Ahmad? Is Tamale here? Tamale, we are sorry, you are good, but we have one placement. The funds did not allow. So we really want to appreciate you, and I really want to hand over to that team. Oh, Jay is here. We were saying that you just left SEHAD. Yes. About 2 weeks ago? Yes. So please say we have treated you well. Or say we mistreated you. Please say we mistreated you or we treated you well.
Good afternoon, everyone. My name is Jay Tumwesige. Atenyi is my impako. I am a student of law from Uganda Pentecostal University, Kampala campus. Last year, just like this year, it was Friday. I participated in last year's constitutional law moot competition, and their lordships, the justices of the Supreme Court, rightly confirmed that I was the best oralist. And it wasn't contested. No one contested that. On that background, SEHAD offered me an internship placement. I went, I did my part. I can confirm on an affidavit that these people treated me very well. Okay? So I'm looking forward for my sister, who has just won as well as the best oralist. Join them. SEHAD treats you, when you go to SEHAD, you home, away from home. So please don't underlook that opportunity. You go there. There is a lot that you can learn, because I've learned. And as I put it in my article, I learned a lot, you guys. Don't underlook what SEHAD is doing for you. SEHAD is bringing something closer that you would have studied in a number of years. Who knows, maybe these things, senior counsel learned them in 10 years or 15 years of practice. But here you are. Things are being brought to you on your table. What it only requires is that you give it your time. So, colleagues, let us take up these opportunities. My name is Jay, and I sign out.
Thank you, Jay. Allow me to hand over to the team to manage, but we really, really, really appreciate you. And I think this is the first moot where we've had a full room. Usually after day one, people run away. I think they get that thing of, we have lost it, therefore we go. But I think the most important thing is for you to stay, because then at this level, you're seeing how things are done in the Supreme Court. Quite different from what they do in the High Court and Court of Appeal. So I implore you that next year, if you have to be here, you please stay behind and see and learn something for yourselves. Thank you so much, and we wish you all the best.
Yeah, I can confirm that after today, coordinators, you won't be receiving those emails and calls from me as much. Anyway, I think we've actually finished. I'm just here to communicate something small. But before I do, has Jay left? Let me just tell you something small in a minute about Jay. So when Jay came to SEHAD and in the litigation department, he told us, I don't want you guys to underutilize me. I want you guys to give me everything and anything that you have. And I want to work, like make me busy. We're like, it's okay, no problem. Sit down. By the time Jay left you guys, he kept saying, you guys, your work, you guys work too much. You guys do a lot. and I'm not sure. Like, I don't know how you guys do it, but you do. We utilized him, and I think he also reached a point where he felt like, here I need to sign out because the work is too much. And that's just how it is. The kind of work that we do, we deal with so many people, and it's just, you know what it is. But anyway, so in conclusion, please don't leave. When we finish here, kindly come behind to our desk. We shall be there waiting for you. We shall give you your transport facilitation, and we have a little something for you to appreciate you. I know we all aren't going with the trophies and the shields, but at least you're going to go home with something to appreciate you for your participation and for always being willing to actually participate in the Moot. Because if we issued the call and no university applied, then we wouldn't have a Moot. But because you guys are willing to apply and also willing to learn, then it is because of you that the Moot happens. So thank you for your resilience every year to apply. Your resilience with sometimes I'm always, telling you things here and there, calling you all the time, emailing you all the time. You guys disturb me, I disturb you. Like, it is all about, all of us putting our efforts together. So we really appreciate you. And even if you did not win, honestly speaking, I'm sure you're not living the same the way you came. I'm sure you learned a thing or two about the Moot. I kept telling my colleagues behind, these guys submit as if they sit with us in office. Because the same things that you submit, I think you guys do so much research to the point that when we come, we feel like you're speaking our minds, or you maybe come and stole our notes somewhere in our office, and or maybe someone from office gave you all these points and you're saying them here. And we also don't live the same. We learn from you. So thank you so much for the effort and time. And we can only say thank you. And I hope you can be able to be together, God willing, next year for the next Moot. And for me, I think, you also have lunch. Please don't go without having your lunch. So when you come, we shall give you a lunch coupon and give you your goods that we have for you. Finally, please don't forget that legal aid box. When you're going out, just get 100 shillings, 1,000, 2,000, and drop it there. That money is for a legal aid fund for child survivors of sexual and gender-based violence. So many people, so many girls and boys go through defilement and rape and incest every other year. Even 3 and 4 year olds. You guys watch news every day about what these guys go through. We are just trying to raise a little fund to support them because there are so many and what we have might not be enough. So please drop that 100 shilling coin. You may never know what it's going to do or that change that's going to bring in that person's life. Please drop it there. And if you're very comfortable enough financially, just go to our booth outside there and buy a promotional item. We have goodies that are that are as low as maybe 1,000 or 5,000, and also we have those of 35,000. Go and buy that Lepo pin, go and buy that bottle, go and buy that t-shirt, because you're also contributing in one way or the other to the legal aid fund. So please, let's do this cause together and save a girl or a boy out there who is going through sexual and gender-based violence. And with that, I think for me, you've been a wonderful team. Forgive me for the rants earlier about being late. I hope you can change next year, but I loved working with you guys, and I hope I can work with you guys again next year. Thank you very much.